Thank you very much, and good day to the two teams. Good evening and good morning to the participants, and of course, good day to our three judges that will be viewing this quarterfinal match, the final one of this year's edition of the Hague Inter-University Law Debate Tournament. Today's topic that teams have received 7 days in advance will be about the domestic export control regimes on dual-use technologies, whether or not they must remain consistent with international obligations concerning transparency, proportionality, and non-discrimination. As always, before we find out the positions, I will be giving the floor to the students for introductions, starting with University of Vienna, Ms. Stadler-Wieder.
Hello, I'm Lily Stadler-Wieder. I'm studying international law at the University of Vienna, and I'm in my second year. And I wish you all good luck for the debate.
Thank you and welcome. From Auckland University of Technology, Mr. Thompson.
Good evening from New Zealand. Good morning to our colleagues in Austria. My name is Tremaine Thompson, and I am a second-year Bachelor of Law student at the Auckland University of Technology in New Zealand. I wish you all the best of luck for this debate. If I may, I would like to just take a brief moment to acknowledge the passing of His Excellency, the Right Honourable Sir Kenneth Keith, who died on Wednesday. Sir Kenneth was an inaugural Justice of the Supreme Court of New Zealand, and most relevantly to this competition, remains the first and only New Zealander to have served as a judge of the International Court of Justice in The Hague. On behalf of the Auckland University of Technology team, we would like to respectfully dedicate tonight's debate to his memory and extraordinary contribution to international law.
Thank you. That is quite honorable. For University of Vienna, now to Mr. Laffer.
Yes, thank you. My name is Leonhard Laffer. I'm a fourth semester law student here at the University of Vienna. And first of all, I want to express my, I didn't know that the judge from New Zealand passed away, and I also want to give respect to the judge. And I guess this is a sad day for our lawyers in New Zealand, but still I hope for an interesting debate today.
From Auckland University of Technology, Mr. Chatwell.
Good morning to my colleagues in Vienna. My name is Jazz. I'm a second-year Bachelor of Law student at the Auckland University of Technology. Very excited for today and best of luck.
Thank you. And from University of Vienna, Mr. Graffinger.
My name is Felix Graffinger. I'm in the second year as well, and I also wish best of luck to our opposing team. And I hope for an interesting debate today. Thank you.
Thank you. In a short moment, you should be able to see the wheel for the allocation of positions for today's debate. All right. There are 4 possibilities, 2 for each team. And it is the Auckland University of Technology from New Zealand that will defend the against position. Thus, we will be starting by hearing opening statements by University of Vienna, defending the argument that domestic export control regimes on dual-use technologies must remain consistent with international obligations concerning transparency, proportionality, and non-discrimination. You have 5 minutes. Thank you, everyone. Your time for final preparation has now passed. We'll be starting by hearing the opening arguments by University of Vienna's debating team. You will have 4 minutes. Just a short reminder, the visual cues are coming from the screen of Mr. Sanchez Cortez Macias. So 30 seconds for yellow card, and when your speaking time is up, comfortably conclude your sentences, but you'll see a red card. We start.
Hello, am I audible? Am I visible?
You are.
Perfect. Honorable judges, esteemed opposition. Our position today is simple. States may regulate dual-use technologies for legitimate security purposes, but they must do so consistently with international obligations concerning transparency, proportionality, and non-discrimination. Because these principles are what distinguish lawful security regulation from arbitrary state conduct. Our case today has 3 parts. So first, we will define the legal principles behind this motion. Second, we will show how broad WTO security exceptions increasingly allow states to bypass those obligations. And third, we will demonstrate that this leads to retaliation and fragmentation of the global technology system. So let me start by clarifying the motion. So international law imposes important constraints on how states regulate export controls. Transparency requires clear and predictable trade-related regulations, reflected, for example, in the General Agreement on Tariffs and Trade, Article 10. However, it's important to realize that transparency does not mean revealing operational security secrets. Rather, similar to WTO law, it means that the governing rules must remain sufficiently clear and predictable to prevent arbitrary enforcement. Proportionality is a general principle, requiring that restrictions do not go further than reasonably necessary. And non-discrimination means that states cannot selectively target trading partners without proper legal justification. Together, these principles ensure that the export controls remain legal, rule-based instrument, rather than unchecked political tools. Second, we will now show how the current use of the WTO security exceptions allows states to bypass these international obligations in practice. Under Article 21b, number 2 of the GATT, states increasingly justify export controls through broad national security exceptions, since dual-use technologies may potentially contribute to military capabilities even outside of situations of war or emergency. This creates significant wiggle room for states to circumvent obligations concerning transparency, proportionality, and non-discrimination, allowing export controls to become tools of geopolitical pressure or economic targeting. So third, once states are able to bypass these obligations, the result is escalation and fragmentation in the global technology system. Historically, dual-use technologies were regulated primarily through multilateral coordination mechanisms, such as the Wassenaar Agreement. But today, increasingly, major powers are shifting toward unilateral export control regimes. The clearest example is the United States expanding restrictions on advanced semiconductor exports. And once export controls are perceived as geopolitical or economic targeting, retaliation follows. So an example for this is the China's export control law that explicitly authorizes countermeasures against foreign restricted export policies. And once this dynamic begins, escalation becomes self-reinforcing because states retaliate, supply chains fragment, and international cooperation breaks down. So, without transparency, states cannot predict how restrictions will be applied. Without proportionality, controls expand far beyond what is necessary. And without non-discrimination, export controls become tools of strategic competition rather than rule-based regulation. So maintaining consistency with these international obligations, therefore, serves an essential stabilizing function. And that is why we urge you to support the motion. Thank you.
Thank you. For the opening statement in the against position, Auckland University of Technology, 4 minutes.
Thank you. Honorable judges, my learned friends, national security cannot operate through rigid external formulas, and international law recognizes that reality. Now, this debate turns on a single question. Who determines what is necessary to protect a state's essential security interests? States themselves or external legal constraints imposed after the fact? We say international law already gives the answer. States retain that discretion. We begin with the legal framework. Under Article 21 of the General Agreement on Tariffs and Trade, states may adopt measures necessary for the protection of their essential security interests. And critically, the treaty refers to measures which it considers necessary. That wording matters. Under the ordinary principles of treaty interpretation reflected in Articles 31 and 32 of the Vienna Convention on the Law of Treaties, those words preserve significant state discretion. Now, surprisingly, my learned friends have not yet relied on the WTO panel decision in Russia, measures concerning traffic and transit. But that may well be because they noted that even that decision recognized something critical for our case. While Article 21 remains subject to limited good faith review, states retain broad discretion in identifying and protecting their own security interests. Because tribunals do not bear responsibility for national security, states do. And the security exception exists for a reason. International trade law recognizes that some threats cannot be managed through rigid external standards. That matters particularly in the context of dual-use technologies. Now, obviously, dual-use technologies are evolving rapidly. AI systems, advanced chips, cyber capabilities, quantum technologies. What appears civilian today may become a serious security threat tomorrow. My learned friends submit an imposition of rigid standards of proportionality, transparency, and non-discrimination on these decisions. But security assessments are inherently contextual. What is proportionate depends entirely on the threat. And states, not international tribunals, are best positioned to assess those threats. The International Court of Justice recognized in oil platforms that security-based measures involve contextual assessments of necessity and risk. That is precisely why international law preserves discretion, because excessive transparency may itself compromise security interests. And rigid non-discrimination standards may prevent states from responding to specific geopolitical threats. Importantly, states already cooperate internationally without surrendering that discretion. The Wassenaar arrangement demonstrates exactly that. While non-binding, it facilitates multilateral cooperation on dual-use export controls through shared standards and information exchange, while still preserving sovereign discretion over security assessments. And domestically, states already operate sophisticated export control systems. In New Zealand, through the Strategic Goods List and Export Control Framework, sensitive technologies are regulated through licensing and executive assessment processes tailored to evolving risks. Those systems function effectively precisely because they preserve adaptability. My learned friends model risks replacing responsive regulation with rigid legal formalism, and that creates real consequences: delayed responses, weakened controls, and reduced capacity to address emerging threats. So stepping back, this debate is not about whether international law matters. It does. The question is whether international law requires states to surrender meaningful control over national security decisions. It does not. Because once states lose the ability to respond flexibly to security threats, they lose the ability to protect themselves at all. Honourable judges, for those reasons, we ask you to reject the motion.
Thank you very much. We'll now proceed by hearing the first rebuttal, starting in favor position, University of Vienna. 2 minutes.
Thank you. Am I audible and visible? Lily macht dann Ton.
You are, but there's a bit of echo.
Yes. Is it fixed now?
Yes.
Does it work now? Okay, wonderful. I will start in 3, 2, 1. Honorable judges, esteemed opposition, I will start to first respond to 2 points of the opposition. First, the opposition keeps presenting existing cooperation and sovereign discretion as though that answers the motion. It does not. Our case is precisely that discretion must remain legally disciplined. Wassenaar shows that coordination and consistency are possible. It does not justify bypassing transparency, proportionality, and non-discrimination whenever security is invoked. And second, they frame this as a choice between rigid formulas and flexible security policy. That is false. We do not ask states to surrender control over security decisions. We ask that those decisions remain consistent with basic international legal constraints so that export controls do not become arbitrary tools of geopolitical discrimination. I continue to support the motion on 3 points. First, the legal baseline is clear. Export controls in this manner are legitimate. Our side does not say that states cannot control sensitive dual-use technologies. In fact, international law requires and permits such control, as the opposing counsel stated. The EU dual-use regulation controls exports, brokering, technology, and more. In 2022, the Security Council of the UN reaffirmed its Resolution 1540, which requires states to establish effective domestic controls against WMD proliferation. Second, legitimacy does not mean arbitrariness. Under GATT Article 21, states have national security discretion. However, in the case of Russia, traffic in transit that was mentioned, the WTO panel held that this discretion must still be exercised in good faith. The case of Saudi Arabia, IPRs, confirms the same logic under TRIPS Article 73. Security exceptions exist, but they are not blank checks. And third, transparency, proportionality, and non-discrimination are not obstacles to security. Transparency does not mean publishing intelligence, proportionality does not mean waiting for perfect proof, and non-discrimination does not mean treating different risk profiles equally. For these reasons, we continue to support the motion. Thank you.
Thank you. For the first rebuttal in the against position, Auckland University of Technology.
Thank you. The proposition's contention that international law requires transparency is misfounded. In the very document that is at the core of this debate, that being the Wassenaar Agreement, it purports no binding obligations on states to adopt the principles outlined therein. However, even then, the transparency mechanisms outlined are expressly voluntary at paragraph 2 of the arrangement. The arrangement also states at paragraph 3 that states remain sovereign in ultimately deciding what export controls look like. This also directly conflates with the GATT Article 21, which explicitly allows a member to withhold security information, again rebutting the notion that transparency must be upheld. This is purposeful to uphold state discretion. Traditional export control regimes, such as the Wassenaar Agreement, were designed for a slower industrial era, not for technologies evolving at the pace of, for the likes AI, quantum computing, or advanced cyber threats. Furthermore, the Wassenaar Agreement consensus process can take years to update its control list, with an average delay of around 3 years. In the context of emerging dual-use tech like AI-guided missiles or facial recognition drones used for mass surveillance, that 3-year delay poses a serious danger for future dual-use tech. A technology capable of military application can evolve from experimental to operational within months. If states are forced to uphold strict transparency and proportionality guidelines before acting, adversaries may acquire, weaponize, or replicate technologies before the necessary export control is implemented. How would you feel if your government waited before acting and it was at your expense?
Thank you. For University of Vienna, second rebuttal.
Am I audible and am I visible?
You are.
Okay, thank you. I will start in 3, 2, 1. Honorable judges, I will again respond to the opposition on 2 short points. First, the opposition misstates our case. We do not claim that Wassenaar itself creates binding transparency obligations. Our case is that export controls must remain consistent with broader international legal principles, while Wassenaar simply confirms that transparency and coordination are already treated as stabilizing values in this field. And second, they confuse flexibility with unchecked discretion. A 3-year delay in updating lists does not justify abandoning transparency, proportionality, and non-discrimination altogether. It proves that only that states need faster mechanisms, not that they should be free to use security as a shortcut around legal discipline. I continue to support the motion on the following points. First, that the legal baseline is clear and that national security discretion already exists under international law is clear, and it must not become a tool for disguised discrimination. And second, consistency prevents escalation and fragmentation. First, the state may act for security, but it must not use security as a legal shortcut around transparency, proportionality, and non-discrimination. This matters especially in dual-use technology because almost every advanced technology can be described as potentially military. The category is extremely easy to stretch. Advanced semiconductors, AI chips, or quantum tools may all have security relevance, but if that alone is enough, then any trade restriction can be framed as national security. That is why the motion is necessary. It requires states to distinguish between a genuine end-use or user risk and mere economic or geopolitical targeting. This is not an abstract concern, and non-discrimination is found of the multilateral trading system reflected, for example, in GATT Article 1 on most favored nation treatment. So the opposition is right that export controls require discretion, but discretion without consistency becomes arbitrary power. For these reasons, we continue to affirm the motion. Thank you.
Thank you. Now for the second rebuttal in the against position, Auckland University of Technology.
Thank you. The proposition argues that broad export controls on dual-use technologies should be proportionate, otherwise they restrict commercial innovation or reduce peaceful trade. However, that argument fundamentally misunderstands the nature of modern dual-use technology. These are not ordinary commercial products. The very same advanced processors capable of powering consumer AI applications can be used to develop autonomous weapon systems, military surveillance networks, cyber warfare capabilities, and advanced targeting infrastructure. My learned friends and honourable judges, I urge that national security is so blindingly obviously far more important than trade efficiency, and the two interests are not equal. When the potential consequence of unrestricted exports includes hostile states acquiring the technology capacity to cripple infrastructure, conduct mass surveillance, or enhance their military operations, governments cannot afford to rely on narrow or delayed restrictions simply because broader measures may inconvenience the global market. The proposition's reliance on proportionality is the particular dangerous point because it assumes that states can perfectly distinguish between civilian usage and military usage. In reality, that distinction is increasingly impossible. Once advanced technologies are transferred abroad, exported abroad, states often lose effective control over how they are adapted, used, or severely weaponized. A government's primary obligation is the protection of its citizens and national security interests. Commercial profit, market access, and corporate growth cannot take precedent over preventing potentially catastrophic security threats arising from uncontrolled transfers of dual-use technologies. For this reason, we oppose the argument.
Thank you. We'll have heard the rebuttals. Now proceeding to concluding statements, starting with University of Vienna for in favor position.
Am I audible and am I visible?
You are.
Okay, perfect. I will start in 3, 2, 1. Honorable judges, esteemed opposition. In our final speech, I will dispute two of the opposition arguments. First, the opposition argued that Article 21 of the GATT and the traffic in transit case already protect sovereignty through security exceptions. However, this actually supports our side. These exceptions show that aligning domestic measures with international obligations does not meaningfully restrict states. Instead, making these principles domestic increases compliance, since states are far more likely to follow international enforceable rules than vague international commitments. The opposition, secondly, also argued that the Wassenaar Agreement proves states already cooperate effectively. However, real-world cases like US-China trade tensions show its limits. Cooperation is inconsistent, widely circumvented, and not universal, since many states are not members. Making domestic regimes consistent with international obligations strengthen these standards, ensuring broader and more reliable compliance rather than relying on weak, voluntary frameworks. Also, While it may be true that the Wassenaar Agreement does not always act quickly, our argument is not that its pace should be directly mirrored international legislation. Rather, we are simply advocating for greater consistency, not just taking it over entirely. Finally, I have to say, because it was mentioned, that we never said about economic profit, and this was just totally wrong. In conclusion, without the consistent application of international obligations governing export restrictions, we risk a significant increase in global tensions and a further decline of international trade. With that, I end my speech. Thank you.
Thank you. Now for the concluding statements in the against position, Auckland University of Technology.
Honourable judges, my learned friends, at the heart of this debate is a very simple question. Who should bear responsibility for national security decisions, states or external legal constraints imposed after the fact? My learned friends say international scrutiny creates stability, but their model misunderstands both the law and the reality of modern dual-use technology. My learned friends rely heavily on transparency obligations, yet the very framework they point to, the Wassenaar Arrangement, not to be confused with the Wassenaar Agreement, contains no binding obligations requiring states to adopt those principles. In fact, the arrangement expressly preserves state sovereignty over export controls decisions. And under Article 21 of the General Agreement on Tariffs and Trade, states may even withhold information where security interests are concerned. Because international trade law recognizes something fundamental. Security threats do not wait for consensus processes. Traditional export control systems were designed for a slower industrial era, but AI systems, cyber capabilities, and quantum technologies evolve in months, not years. My learned friend's model requires states to satisfy rigid standards of transparency and proportionality before acting. But by the time those processes are completed, the technology may already have been transferred, replicated, or weaponized. And once that happens, the damage cannot be undone. My learned friends also frame this debate as trade versus fairness, but these are not ordinary commercial products. The same processes capable of powering civilian AI systems may also support autonomous weapons, cyber warfare capabilities, military surveillance networks, and strategic targeting systems. And in that context, national security and trade efficiency is simply not equal interest, because governments cannot gamble national security on the assumption that civilian and military end use can always be perfectly separated. International law recognizes that reality. And once states lose the ability to respond to these threats flexibly, they lose the ability to protect themselves at all. Honourable judges, for those reasons, we ask you to reject the motion. Thank you.
Thank you to both teams and congratulations on completing your quarterfinals debate. You can all now relax. You're no longer graded after this part. Before we proceed to the feedback part, I just want to acknowledge that it's quite a well-matched debate that happened today. For both teams, it is a first-time participation and you have passed straight to the quarterfinals. So you are quite well matched also in terms of your progression in your first participation. For both teams, you have 3 wins under your belt before this debate. So really well done. I think you have a lot to be proud of as well for representing and showcasing your skills and that of background that your university gave you. And of course, your work for the debates, for the research, and for the execution of your research during the debates itself. Of course, the judges will be giving you the detailed feedback through the scoring cards, and as soon as we have them, we will be sharing the feedback with you and announcing the results. But as our tradition gives, I would like to invite you for the round of feedback amongst yourselves. How did you find the debate, the topic? Perhaps familiar arguments were heard, and perhaps a twist on it. How did you use your previous experiences for today's debate preparation compared to the previous matches? And now starting with Mr. Laffer of University of Vienna.
Yeah, thank you very much. I think it was a really interesting topic. Again, I would say. I didn't actually know what dual-use technology was before I heard this debate, but I think it's really an interesting problem that international law has, because these products can be used for civilian and war purposes. But generally, it was a really interesting debate. And what I really noticed that we both had really similar examples. So this was something that recurred to me a lot. And yeah, I just had a lot of fun today. And thank you for the podium team for making this match happen.
Thank you. From Auckland University of Technology, Mr. Shatwal.
Likewise, dual-use technology was sort of a bit, I don't know what that is, until starting to research the topic, found the various treaty law, etc., quite intriguing to research. Yeah, I would say one thing that we learned from our previous experience, the twist that you added to the question, being able to keep track of exactly what the opposition is saying and being able to write it down and utilize that in arguments in the conclusion and rebuttals.
Thank you. Now to Ms. Stadler-Vida of University of Vienna.
I can just agree on what was already said. What I can add is that I really enjoyed with this motion today, and that the research was more legal based, so it was really nice to dig into like all the treaties and stuff. It was really interesting, and I really enjoyed that.
Thank you. Mr. Thompson of Auckland University of Technology.
Yeah, I agree with what everyone else has said. This debate topic was quite interesting. It was quite confusing at first and took a while to get our heads around it. Big shout out to Professor Kylie Quince and Dr. Myra Williamson from AUT for at least looking into how we could decipher what this topic was. Yeah, no, really enjoyable debate. I really appreciate the style of debate from the University of Vienna. I thought you all did really well, and it was very enjoyable. Thank you.
Thank you. And now to University of Vienna, Mr. Krakener.
I can also only affirm what my colleagues have said, and I also, in that line, want to say to the opposing team, congratulations on doing so well up until now. And it is very refreshing to hear that we're not like the only first timer that has been able to advance, and therefore I'd equally be happy for you as I'd be for us if you were able to advance, also because you did wonderfully today. And then to the networking question, what was very new or what we were able to use from the past debates for me personally was the feedback that we got through the scoring sheets. I really appreciate that this is a feature and that this is done, because I've done a moot court where the judges were not allowed to give direct feedback. So that is greatly appreciated, and we've been able to implement that, for example, on hard law examples or similar issues. So please keep that feature in line. It is wonderful, and thank you to the opposing team again.
Thank you, and really, once again, well done to your teams. It's been a pleasure seeing your debates from the beginning to the end.
Cette réunion est enregistrée et résumée.
There we go.
I think we're back.
Yes. There you go. The YouTube's still working.
Excuse me. Cool. I am still unsure which profession, but I'm currently working more towards being a judge. And how this relates to this debate tournament, I mean, I'm also a bit hoping, although I think it's difficult, to maybe become even a judge in international law or like in something international. And I think this is like where this debate might come in handy, but yeah, I'm still studying quite long, probably, so it's still uncertain.
Similar position to my learned colleague, only in my second year, obviously. So still looking at various different options, leaning more towards doing some form of litigation, either civil or criminal, which is very broad, but definitely want to be involved in the courts and advocacy.
Yeah, I'm also still figuring everything out. I'm really like looking forward to do some internships and see what really catches me. But I think nowadays it doesn't matter in which field you actually go because international law plays into most fields, I would say. So yeah.
Yeah, I hope to become a lawyer focused on advocacy, public interest work, and serving communities that are often overlooked. I think my experiences as a first responder, founding the South Auckland Law Students Association, as well as competing in mooting and advocacy competitions like this, have all really reinforced my passion for using the law to support and advocate for people during some of the most challenging moments of their lives.
Yes, I likewise am rather early in my studies, but luckily, and I don't want to once again plug ourselves, but luckily through the debating society, I've gotten to know a lot of different people and friends. And then I have to say that I really can't decide yet whether I'd like to stay at uni, where I have a job at uni right now, and I really enjoy it, and I really enjoy the people, or whether I'd like to immediately start into the legal profession, or also, for example, arbitration or litigation cases where you can maybe argue more freely, similar to debates like this. And all of these options are very interesting to me, and there are even more, and maybe even some that I don't know of. So it's a really hard question to answer, but I appreciate also to be able to hear from the others what their ambitions may be.
Yeah, thank you very much. I will start. Actually, I will go on my exchange semester this September. And actually, I will also go to the Netherlands, so it's all engraved in stone already. But yeah.
Yes, I personally haven't yet set in stone where I may take my semester abroad. And now seeing that, for example, law students from New Zealand are very capably built up to be lawyers, I may even decide to go to New Zealand. So I would already have great connections there. And then also I've recently befriended some people at MUN in London, so that would also be very interesting to go there. And I'd just be glad to get to know any culture or different university for the matter of that fact. And also, before I end, I want to thank once again the organizers and the coaches, because it has been like very stress-free and very problem-less up until this point. So I want to thank you for that. And I believe maybe like the crash is maybe the first thing that you didn't even have control over, that somehow was not exactly according to plan. So yeah, thank you for that.
I haven't decided yet either. I would really like to go to study in Budapest for a time because I have a lot of family there. And I would really like to do like a postgraduate thing, for example, in Montreal or something like that. But still, everything's still in the future. So we will see.
Well, first, you're more than welcome here at Auckland University of Technology in New Zealand. Do feel free to reach out if you would like some information on our study abroad program. But I would really love the opportunity to study in either The Hague or the United Kingdom, or possibly Canada or Spain, particularly in international law or even Catholic canon law. That's another kind of pathway that I'm interested in going down. And I really would hope to gain a broader perspective on justice and advocacy and learn from different legal systems and cultures, as the team from Vienna said, and bring those experiences back to better serve my community here in New Zealand.
Similar to all the colleagues here today, haven't really ever thought about where I would go. I would probably have to say somewhere in the UK, as Tremaine mentioned, and what I would hope to bring back is just, again, the different understanding of legal systems, plenty of different legal systems in Europe. I've mentioned the French legal system before in a separate debate, which I find quite intriguing with a lot of the civil code. So perhaps that.
Thank you very much. And really, once again, well done. You have a lot to be proud of and happy with for your past performances and today's performances included. So really well done. I hope you have a lovely start to the week from yesterday to today. For Auckland University of Technology students, I hope you have a calm evening and wrap up of the day, and a good start to the day to Vienna. All right. Thank you to my colleagues, Mr. Sanchez-Cortez Macias, and of course, Professor Lovange. And we hope to see you at the next event. be that in person or virtually.
Bye bye.